Welcome, everyone. I'm Devin Thorpe, and I am the 2023 president of the Crowdfunding Professional Association. We have an extraordinary panel today, and this has been so popular. We've just been almost overwhelmed by the number of registrations for this event. It's certainly been the most registered event we have ever put on our webinars, and I'm excited to see the crowd forming now as we launch this session. Of course, we'll record it for anyone who's not able to catch it live, and we'll be sure to send that recording to everyone who registered, as well as to put it on our website. But this was going to be an extremely important panel discussion today. In a moment, I'll introduce our moderator, Sara Hanks, but let me just take a moment before we start to introduce you to the Crowdfunding Professional Association. Some of you are new to us, and I want to make sure that you know who we are and what we're doing. It's the leading national association of people participating in crowdfunding, including the portals and the broker-dealers who act as intermediaries, but also we include the investors and the issuers, the companies that are using crowdfunding, the entrepreneurs, the business owners, and we also rely heavily on the experts like those on the panel today to be an important part of this community to help protect investors and make crowdfunding easier for entrepreneurs and other issuers. So we're excited to have this great group together. Each month at this time, so the time right now is 2 p.m. Eastern, and each month on the second Wednesday of the month, we do this webinar, and we share great insights every month. And so today we'll be talking about annual report compliance, and I'm sure the panelists will get into this, but the compliance with annual reporting requirements isn't great in the industry, and so we need to figure out ways to improve it. And so Sara Hanks, who is the CEO and founder of CrowdCheck, an eminent lawyer in the space who has been in the community since before the Jobs Act passed. She's part of that group that lobbied for its passage and is an exceptional, extraordinary person. I'm thrilled to count her as a friend. I hope she doesn't resent that, but Sara will take the time to introduce or have the panelists introduce themselves. But Sara, take over, take it away.
Okay, so thanks, Devin, and I'm delighted to be doing this. I was first delighted when Devin said that we'd do a webinar on this topic, because it's very near to my heart. Running a compliance company, it hurts my heart when compliance does not happen, and anything we can do to make it happen more is great. And I did say to Devin, well, but if I'm going to be the moderator, I'm not going to be able to rant about people not complying. And he's like, no, go ahead, go rant as much as you like. So on the basis that we are going to be talking about compliance in an area where compliance is really not happening as much as it should, delighted to be joined by Peyton Theodore, Maureen Murat, and Brian Korn. I'm just going to ask each of you to give a couple of sentences about you and your practice and how it ties in to annual reporting under Reg CF. And we'll start with Peyton, maybe.
Hi, Sara. Hey, everybody. Great to be here. I am the COO at LawCloud, where we help platforms and their founders with their SEC filings, including the Form C, as well as the Form CAR.
And Maureen.
Hi, everyone. My name is Maureen, and my business is called Crowdy Advisors, where I help issuers also fill out the Form C and help them get onto the platforms. But we also take, it's dear to our hearts to help them understand why they have to do some of the things that they have to do. So it's nice to meet you.
Thanks.
Nice to be here.
Thanks. And Brian.
Hi, folks. Thank you for having me, and great to be on this great panel. Brian Korn, I'm a partner at the law firm Manat, Phelps & Phillips. in New York. We work with all types of companies and individuals in capital raising, fund formation, looking at alternatives to public offerings. And one of the things we do is work with clients who are thinking about using Reg CF and comparing it to some of their other options so that they have the best choice.
Well, thanks. And that sort of leads us into our first question here. I mean, we're talking here about the annual filing requirements under Regulation CF, Regulation Crowdfunding. And really, there's not a lot to it, although I think Maureen's going to challenge that, because all you have to do is 120 days after the end of your fiscal year, you file a Form CAR. And Brian, you were going to discuss where in the continuum of all of the things the SEC requires companies to do, does the Reg CF fit? Does the Form CAR fit?
Yes. So CAR 120 days, which is not 4 months. It's actually April 29th in a non-leap year. So that's the first tip of the day, is don't get tripped up by thinking 120 days is 4 months. You have to think about February and the different other days. So there's an easy program, by the way, that tells you any date besides Google from a given date. And securities lawyers love that tool. Clients usually come to us. They don't say, I want to do a Reg CF. They say, I need to raise $5 million, or I need to raise $2 million, or I need to think about funding my business somehow. And so what usually happens is a discussion around what the different options are, which would include all manner of capital raising. The securities laws in the United States require that that an offering of securities be either registered or qualify for an exemption. Registered offerings include public offerings such as IPOs. They are the most expensive to execute because they require a filing with the SEC and a review period and comment period where you have to respond. And they're most onerous in terms of disclosure. Private placements under Regulation D of the Securities Act of 1933 allow parties to raise capital without going through an SEC review process by selling to either accredited investors to whom you had a pre-existing relationship, or those whom you have solicited to under the Reg D rules. Reg S allows you to make offers and sales to participants who are offshore, provided you don't make directed selling efforts in the US. And then finally, Regulation A, which is called the small offering exemption, or it was before Reg CF, allows you to raise up to $75 million, raising capital from both accredited and non-accredited investors in a 1 year period. And so it's the most similar to Reg CF. Reg CF is something that had been talked about for a long time. In 2012, it finally came to life as Title III of the Jobs Act. And what it used to have is a $1 million cap. Now it's been increased to $5 million. And it allows you to raise capital under certain investment constraints from accredited investors and non-accredited investors. And one of the conditions of complying with Reg CF is the filing of various forms of Form C, including the opening Form C, closing Form C of the offering itself, and then what we're talking about today, which is the annual report, the CAR. It's essentially the same form as the Form C, and I'll let our other experts get into the details on how they differ. But in terms of other exemptions, the Form CAR is only required once per year. Under Reg A, you have an annual filing called a Form 1K and a semi-annual filing called a 1SA. And in the public offering world, if you become a public company, you have an annual report on Form 10Q, 3 quarterly reports on annual report on 10K, 3 quarterly reports on Form 10Q, and then periodic reports for special events on Form 8K. So it's a much more onerous process compared to the
Okay, so when you look at it in that context, it sounds like CF is so much less of a burden than if you were doing an IPO or whatever. But Maureen, down there in the trenches, when you're dealing with teeny tiny little companies, I think, I say, well, it's super easy. Come on, it's so short. But you're out there dealing with the companies having challenges. Do you want to get into, what are the challenges that the companies are encountering with the CARs?
Sure. And I mean, I also, to your point, a lot of times these are very small companies. And so compared to a company who's going public, who has tens of millions of dollars in their coffers and they can pay, firms and all that stuff to help them fill out these documents, the traditional startup or small business just doesn't have those resources. The other thing is, there are oftentimes where it might seem easy because you just have to put some of these things together. But I think the issue is that issuers don't also understand some of the terms, right? We talk about like some of the main components of, the CAR, in addition to what the name of the business is and where it's located, et cetera. You have to provide, financial information. And there are some filers or some issuers who actually aren't operating yet or don't have really a lot of revenue. So, and they're not really keeping track of it for whatever reason, whatever revenue they have. The other thing is, when it comes to reporting, what's considered a successful filing. So some people don't meet, I think the success rate now, I think as of 2020, it was it 50 something percent? I think it's gone up a little bit more, but in terms of, meeting the success rate, if you don't, meet the amount or reach the amount that you wanted to raise, it's not considered successful. And then people just kind of, for not that I'm condoning this, they're just like, oh, I didn't raise the money I was supposed to raise. The money all went back. And, you just kind of leave it at that. Or maybe, they had tiered raises and they only raised, the minimum, which is like, let's say $10,000. And so they're like, oh, I only may raise the minimum. And so they, for some reason, don't think that there's more to it than just raising the money. I also think, and I'll, stop here, but I think the issue also with the small businesses is sometimes the, trying to determine like what securities are offered and filling out the form and them doing it on their own can be like could be a heavy burden for this small company who's also trying to run the company, who also is trying to, sell whatever their product is or build or whatever. So I think all of that, it does seem easy if you think about it compared to what some of the other companies have to do. But I would say that it's actually harder on the smaller companies because they don't have the resources that some of the bigger companies have.
Yeah, that's a really good point about the whole resources, because when you look at it, as Brian said, the CAR is not that different in content and slightly lesser than the Form C. And the thing that I keep running up against, and I'm going to emphasize this like a million times, is that the financial statements that have to be filed don't have to be reviewed. They don't have to be audited, but they do have to be prepared in US GAAP. And QuickBooks is not GAAP. It never will be. And it's, you cannot use cash basis accounting. That is not GAAP. And so that to me is one of the biggest challenges, is trying to get that kind of compliance. So Peyton, are you seeing that? I think, with Law Cloud, you get to see a lot of, what's coming in initially. Are you and the folks that you work with going, whoops, that's not compliant?
Yes, yes, we get a lot of questions and a lot of confused founders. And one of, I guess, the basic things that people tend to have questions about are what are US GAAP financials, right? So it's the 4 financial statements. It's the balance sheet, it's the income statement, it's the cash flow statement, and it's the shareholders' equity statement. So we try to educate and empower, and we really like to do that from the get-go. And I think that's where a lot of the intermediaries tend to fail, is they might not mention the CAR. And if it's never mentioned, then it comes as a surprise. And no one likes to have a surprise bill, right? Especially whether their raise was successful or not successful. People don't like to find out late that they had a requirement that they didn't meet, or that, could have been prevented. So we try to educate a lot. And we try to get answers to these questions. And even amongst securities attorneys, you'll find different interpretations of the SEC rules. So, I think that's a great clarifying point. What does it mean to have sold a security, right? And does it mean that that's when someone has invested? Is that what it means only if I've closed my campaign? These are a lot of the questions that we get, and always try to bring in the legal advice of a securities attorney.
Thanks. And when we were putting together this webinar, one of the things that we were discussing as a panel is the fact that, there seems to be a lack of clarity out there with respect to when you have to, when you've triggered the requirement. I mean, the requirement is triggered by you've made sales, and there seem to be some people who think, well, if it's 2023 now and I made sales in 2022, then I file. But if I didn't make sales until 2023, then I don't have to file. Absolutely wrong. And I've got, my favorite story in this field is from years back, in the very early days of Reg CF, when we had somebody, basically, very fancy society lady, very rich husband. She had a little enterprise that was basically a hobby farm, and she wanted to raise funds for it. And there was no take up. And she sold nothing until we got very, very close to the April 29th or 28th day, when things would be due. And she was so upset about this that she had mentioned it to some of her ladies who lunch society friends, and they all invested. And they all invested like 2 days before the due date of the filing. And we had not been prepared. We thought this was just going to be a failure of of an offering. And so we went to the SEC and said, she didn't know, she didn't have time. And the SEC said she made the sale, these sales were binding. She was hoping that the sales would be made. Therefore, she has a filing obligation for these sales that she made less than 2 days before the due date. File the form. So we had to do that in very short order. But that sort of that relates to one of the issues that I think, Maureen, if you want to weigh in on this, and the whole when are sales made, and tell us what about the we all know there's a 48-hour period. During which, once you get to that point, you can't back out. So, is that where we trigger the obligation to file?
Yeah, so I would, I guess, piggybacking off of what Brian said already. You hear 120 days and you think you have all this time, and you may not. But yeah, so the 48-hour period is the period that the investor has for the money, because they have a period where they can redeem it. So if it's after they purchase the securities, if they don't redeem it after that 48-hour period, then that becomes final. But then you have a whole fiscal year of sales, right, that you have to account for as well. And yes, I guess 120 days is after the end of the fiscal year, but not really, because you're counting up until the date. And I think that's something where I know we're not really talking about the platforms, but this is something where you leverage the platform, right, to help you get that information in terms of the sales that you have made. But I mean, the requirement is there to kind of keep, the issuer on track. And I know that, we're talking about, the issuer not having resources and things like that. And sometimes the platform or the funding portal is not as helpful as we think they are or maybe should be. But you know, it essentially keeps falling on the issuer to have their stuff together, right? To have their things in order. And that means keeping up with the deadlines and putting things on your calendar or putting it in your phone or whatever you need to do to make sure that those documents are submitted on time.
And let's keep rolling forward. Brian, do you want to talk about how long does this requirement continue? I see in the comments we have a question about, does it get filed once the following year or again and again and again and again? So how many agains do we have to go through?
So and one thing I'll say also is it's not just the filing of the CAR, you also have to post it on your website. A lot of people don't remember that, and they just think they're done when they file, but there has to be a post. Just a hyperlink is fine,
right.
Or a PDF link, but it also has to be posted on the website. So there are 5 ways you can get out of filing a CAR. The first is if you do become a public company and you're subject to the Exchange Act sections 13A or 15D. There have been some crowdfunding rounds that have gone to public filings. Oculus got acquired by Facebook, and they, although that was a rewards campaign, I think, if I remember correctly.
Yeah, it was. Yes, it was.
There was a lot of confusion in that because a lot of the rewards crowdfunders thought that they were entitled to compensation for the acquisition, but it turns out they realized that they were actually just rewards purchasers, not investment purchasers. Second is after you have filed at least one annual report and you have fewer than 300 holders of record, you can file a document called a CTR, which is a termination of reporting, and that will suspend your obligation to make any further filings until you go over the 300 in a subsequent capital raise. So the example of the woman who raises a lot of money, but not from more than 300 people, that person can file the CAR and then immediately file a CTR, and their obligations will end there, as long as they are 300 holders, less than 300 holders of the same class of securities. That's also important. 3 is the issuer has filed 3 annual reports and has total assets of 10 million or less. The 4th is the issuer or another party purchases or repurchases all of the securities issued pursuant to Reg CF. So if you have done an offering and you buy them back, you can terminate your reporting obligations. And then 5 is liquidation or dissolution in accordance with state law. So if you dissolve or no longer exist, then your crowdfunding Reg CF reporting obligations suspend.
Oh,
Can I add something?
Yep, Maureen.
Yeah. Oh, I was just going to say, and I think the beauty of Reg CF is that you can, one of the beautiful things about it is that you can, raise, up to $5 million, in a 12-month period. So if you're able to come, do a campaign, come back the following year, do another campaign. I mean, obviously you have to keep reporting, but at least you can, kind of continue that trend of raising funds via Reg CF if your business allows and you have the investors who are interested in purchasing securities.
Yeah, now that's an interesting point, because you're talking about coming back to do further offerings, and one of the requirements of being able to do further offerings is the fact that you cannot have had an obligation to file a CAR and not have complied with it. So just looking at who's responsible for making sure that this happens. I mean, who is responsible? I mean, Peyton, you were talking about the fact that the intermediaries don't really help on this, and that you're having to help the companies through. Is that true?
It is true. And we have had companies come to us who have done multiple raises but had not filed a CAR, right? So yes, it's, you know, it's fairly messy out there. There's also a lot of complication with the SPVs. Last year we had really our first year of SPVs filing their CARs, which added a whole new complexity to it. And so I think it's the issuer's problem, right? But it's not just the issuer's problem. And I think for the industry to maintain integrity, I think we all have to do what we can for this compliance issue, because it's going to keep the standard at which, you know, we're running business very high, which is so important to continue and have longevity. So we do our best. And when we use our network of securities attorneys, they'll work with issuers on, you know, how can we bring you up to compliance, right? Do you need to file multiple CARs this year? What can we do to make everything as clean and as organized as possible?
Yeah. And one thing with respect to the intermediaries, and I do want to emphasize this because I keep seeing this, is as Peyton has identified, there are companies who are trying to do a follow-on offering, and they have not, they are out of compliance. And sometimes the intermediaries will just be, oh, you should have filed last year, go ahead. You've got to go all the way back to see all of the filings they should have made, because you've got to, you know, go back. The eligibility to rely on Reg CF is dependent on the issuer being in compliance with this requirement. And so until they are in compliance, they're not going to be able to raise. But one of the things that intermediaries especially have to do is go back, make sure that all of the filings were made and that they were compliant, that they weren't using QuickBooks. Otherwise, you know, Brian, do you have any ideas on you know, how you go back and fix the failure to file?
Yes, so under Reg CF 100 B5, again, if you've done a crowdfunding offering under Reg CF, you have to file all required annual reports during the 2 years immediately preceding the filing. So if you only have to fix the last 2 years. But in terms of how to fix it, it is refiling or filing for the first time, I guess, the CAR for the missing years, including the financial statements that are prepared in accordance with GAAP. So unfortunately, you would have to go about to do that. The only other potential workaround is if you were raising capital for a different project and you form a new company and you're effectively deciding, well, this is something that wouldn't be integrated with our original company, that, you know, there was a different management team and for whatever reason they weren't compliant, but I'm forming this new business, I'm going to be compliant. That as long as you're bona fide and being independent, you can do it that way. But for most companies who are raising capital for a different time and they haven't made the filings, they have to go back and file at least the last 2 years.
All right. So one of the things that I'd like to emphasize with respect to you know, what Brian was just saying is, you know, when we have this situation, we like to, you know, have our clients, they've got to file everything again, and we say, you know, file in the order in which you would have expected to see them originally, so you don't confuse the heck out of everybody trying to go through Edgar. And one of the issues I wanted to emphasize here, and we'll get into, you know, compliance in general in a second, is there is, I see a very cynical viewpoint with respect to the filing of Form CARs. Because we see sometimes companies who are, they really don't want to give up the information. They're like, hey, yeah, we've got financial statements, we're actually doing fairly well, but we do not want to share that with our competitors. To which the answer is, you should have thought of that before you got into the Reg CF system in the first place. To emphasize what Maureen had said, which is, think about what you need to do on a going forward basis. Because what we're seeing in many cases is a company is like, there's no penalty. Nobody's been sued for not filing a CAR. Nobody has been prosecuted by the Justice Department or sued by the SEC. And since there are no penalties and there seems to be no downside to non-compliance, I'm not going to comply because I don't want to share my financials. And then you come back 2 years later and the company is like, I really would like to raise another 5 million. So now I'm going to file all of the financials because, cynically didn't have to now. And that's the penalty I pay. And then they rinse and repeat. They will do it again. And Maureen, you're nodding. So you've seen this practice too?
Yes. And I would say, it's not an issue until it becomes an issue, right? So, you could potentially just not follow them and then follow them when you need to raise more and all that. But, one day, he's like, okay, we're going to just start paying attention to these filers of the CARs. And then they're just, sometimes they come down with a hammer and it's swift, right? So, I don't think it's worth it to skip it when you're supposed to do it anyway. Because why not do it? But my other issue with people not wanting to share information, when I think about people who say, oh, I don't want to share with our competitors, I'm like, yeah, your competitors will see it, but you're really sharing this with your investors. These are the people who backed you, right? And so you want them to potentially back you again. You want them to potentially use your product or whatever. So, you also want to keep those investors informed. And yeah, oftentimes, maybe the amount of the investment is, low, let's say 250 or 1,000 or whatever. But they're still your investors, they're still your backers. And if you said you were going to use this money to make money to do this, then you should let them know. I think the focus is on the wrong group of people.
Yeah, I couldn't agree more. I think there's a moral aspect to this, which is you took people's money. You said you would give them information. You haven't. That is a moral failing. But setting aside the moral issues, what about possible prosecution or lawsuits? Brian, do you have any thoughts in that area? If we've got your audio back,
I think my audio is good. Yes. So I'll speak up. I think that your original Form C said that you're going to make the filings. So by failure to make the filings, you effectively possibly engaged in fraud by inducing people to invest in your transaction who are not going to get any information about their investment or the company. It would probably be a material omission to not disclose in the second time that you willfully or otherwise didn't make the annual filing requirements in the first offerings. So if I were a funding portal, I would think very long and hard about having you put a transaction together again. I know that there's this carelessness or willingness to disobey the your own disclosure in the document, which is required to say that you're going to make annual filings. I also am with you on the moral side. I think there is an SEC enforcement case that can be made here, especially if they can show willful intent to defraud. There's a 10b-5 case, and it seems the staff might be occupied with a lot of other issues right now, but I would not assume that because you have not gotten caught or pinged by this, that what you're doing is okay.
Yeah. And I do see, I think you're right. The SEC is kind of busy on a whole bunch of other things at the moment, and I think it would be good. I would love to see more enforcement in this space, to be honest, because there is so much failure to comply. But one of the things that we are seeing is the FINRA stepping into this, and FINRA actually enforcing things again and taking enforcement actions against some of the platforms for things that you'd think that it would be the SEC's job. So that's kind of interesting to see them do that. With respect to compliance, all right. So we're all saying that there is a failure to comply here. We haven't seen very many reports on this. I know that Woody over at CCA some years ago did an analysis, and it looked like the failure rate was something like 30%, as in only 30% of the companies who should have filed a CAR didn't. It's kind of difficult to measure because, of course, you don't always know whether the offering was successful, because a lot of them are not filing their Form CUs to tell you what happened. So there's a whole nother area. We can do a webinar on failure to file CUs at some point. But does anyone have any idea, and here it's going to have to be anecdotal, ballpark estimates? Peyton, how many people do you think are failing to file forms they should file?
It's definitely the majority, right? That we all know. The exact figures we might not have. It's definitely the majority, although I do think every year our numbers increase. So I'd like to think that's moving in the right direction. I think with any industry that's new and goes through such extreme growth periods, it's normal to have adjustment periods, growth periods. So again, I think as we can educate people more, offer cost-effective solutions, I mean, it would be lovely to even condense the CAR to make it more attractive to founders to complete, right? To make it more simple, to make it easy for people to comply. I think the industry, should support as well. But it's definitely been the majority. But I think these webinars, we have more and more every year. And I think that gets people's attention. Articles get written. It starts to get to be more of a norm in the industry for people to understand that this is part of it. I mean, there are a lot of great life lessons in crowdfunding, right? I mean, what kind of a foundation are you building for your house or your company, right? You want to line things up properly and put the right intentions and energy in when you start something, because you want it to be long-term and you want it to grow, and everyone wants to be successful. So I think by learning what makes a successful campaign, right? It's not just trying to make people marketing and make people think, oh, it's so easy to raise $5 million. But there are obligations that come with that, and there's discipline that comes with that. And there's a lot that has to be put into a business, right? Even from forming it to filing annual reports, it's taxes, right? It's all that not fun stuff that we all have to kind of go, okay, well, that's part of it too. And I need to do that. I need to do it.
And staying with you, Peyton, since we've got a question that's sort of right on par here, could the process be made easier by essentially copying the C and adding the updated financials? Kind of what the process does, right?
Yes. I mean, because we work so much on the Form C, I find with most founders, it is a surprise how much work has to go into it, how much detail. And again, I think it's that a lot of people think raising money should be easy, or maybe they heard it is easy if you do it in a different way. So to some, it seems easy, right? If you've done a public offering, or if you've raised 75 million versus just a couple 100,000. But yeah, could it be made easier? Could it be made more simple? What's critical for people to know on an annual basis about what material changes have taken place, what your campaign has done, what you plan to do in the future? what are those critical pieces, and how can we let people submit them in a way that's super easy? I think it could be more simple from my perspective.
Maureen, do you have any thoughts there? I mean, is it simpler? Is it the complexity, or is it people don't understand? I mean, why are they failing at such a high rate?
I think it's a little bit of both. I mean, to Peyton's point, there are all these different sections to it that, because the Form C seems like such a heavy lift in the beginning, you think, going forward, it should be a little simpler. And to some extent it is, because you're using a lot of the same information you had put in your Form C initially. You're just kind of updating it and all that. But I think one of the issues why it's the success rate or the filing rate is so low is because people don't understand. And if it's a small company, they're also kind of spread thin, right? So they might not have, enough people to actually be paying attention to the compliance side of things, which is very, very important, to Peyton's point, because after you raise the money, that's really when it all, the work begins, right? Aside from the reporting requirements and the taxes and all that, you then have to actually do what you said you were going to do with the money. So I think, sometimes the teams are spread a little thin. But I also think some people feel like, I don't know if it's just one of the things where they're like, oh, the government's just asking too many questions. I'll get to it when I get to it, and, obviously that doesn't bode well in the end.
Right.
I don't think that people are, I think a lot of people pay attention and keep in touch with their investors, but maybe often forget to do the ministerial paperwork of the Form C updating. And that's probably the majority of the folks that are out there. They don't want people to just not know what they invested in or not get any business updates. The Form C AR is designed to update people on the business and the offering, how the offering went, how much did we raise, what are we using the money for, when are we going to do another offering, how much cash do we have, what's our runway. These are all things that get addressed in the annual report. And I think a lot of companies do that offline and through phone calls and through letters to shareholders and, maybe other meetings.
Brian, do you think that's
fair.
the larger companies?
Yeah.
Well, I think even small companies want to be compliant. I mean, you're effectively using a national crowdfunding rule, meaning that you're going to spread your net across all 50 states and DC. You could have stayed local and done an intrastate offering or just raise money from friends and family or your own community off of Facebook, but you've chosen to go through the process of doing a real raise. I don't know why somebody, it doesn't cost that much money to get one of these filed, especially if you've raised, tens of thousands of dollars in the offering process. It's kind of the cost of doing the deal. And if you haven't raised that much, you can probably only file one and exit out. So, I think that's the issue. Maybe the SEC doesn't want to discourage people though, so it hasn't come down too harshly on non-compliance here, because there's a lot of novices in this world compared to the Reg A world or the public world where there are severe sanctions for not filing, and so almost everyone does.
I think that's a good. Sorry, Maureen.
Oh yeah, no, I was going to say he does. That I was going to agree with Brian. I think it makes a good point about companies not necessarily not wanting to do it. But to your point, Sarah, about the size of the company and all that, I think being a bigger, a small business, I think helps, because even if the CEO or whoever the head is not necessarily focusing on, keeping the compliance stuff together, they might have someone on their team who would be doing that. Whereas some smaller companies might not have that person dedicated. Yeah.
Yeah. And I think, one of the things about to respond to one of the things that Brian was saying, the SEC has sort of not come down on anybody because it looks really bad. You know, you've got two guys and a dog in a garage raising money, and maybe they're going to be like the next IBM. And the SEC has come down on them for not having filed this stupid little form that needs to get filed in April of every year. And why did they do that? And I think that's one reason why we haven't seen a lot of regulatory action in this space.
I think a lot of I don't think it's too difficult. I mean, if I offered you, Sarah, $2 million and you have to file a 10-page report once a year, right? That's like winning the lottery. Why wouldn't you do it? I think what the problem is that it exposes people who have inadequate financial controls or who have embarrassing items on their financial statements, such as inappropriate purchases or you know, maybe they've invested poorly in equipment, or they just haven't, you know, they don't have a full-time accountant, or, you know, it's maybe the financials are just a complete mess, and you know, they're not looking to publicly acknowledge that. I mean, that's part of it too.
Yeah, it's the cynicism that I mentioned earlier about like, I'm not, you know, I know my financials are terrible. I'm not going to go. I just don't want to expose it until I need to. But you know, following up on that, I mean, you know, how do we fix this? I mean, who is responsible for fixing? Is it the SEC? Is it the states? Is it FINRA? Is it issuers' lawyers, plaintiffs' lawyers? I go, Peyton, do you have any thoughts? And we'll go round the gang.
I mean,
who's going to fix it?
Yeah, I think I touched on it earlier. I think it's going to be a group effort, right? I think it's making it as easy as possible for the issuers, so there's no reason that they wouldn't. I think it's building it into the process from the beginning. You do a Form C, maybe that's included in your Form C pricing is your first CAR. So it's there, it's built in, you know about it. Education, empowerment, all of these things I think will be critical to see it. And at some point, the punishments, coming in and holding people accountable. It needs to be kind of sold to founders as, you know, you brush your teeth, go to the dentist, you pay your taxes, you do your CARs. And so we normalize it. So people they're not grumpy about it, you know, they just kind of accept it, and it's part of what people do.
Maureen?
Yeah, I would add to that group the intermediaries as well, right? Because, I mean, to your point earlier, Sarah, you know, they do have to make sure that these companies are compliant. And sometimes, you know, oftentimes it just stops at the Form C, and there's just so much more to it. So I think the intermediaries have a role to play in that as well, especially because they have the technology. They could send a trigger, you know, or even put that in one of, you know, in the checklist that they give them, you know, to get onto the platform, you know, to make that stand out somehow. So, and I agree with Peyton. I like the idea of kind of folding it into, you know, the Form C also includes preparation of the Form AR. I think that's a great idea too.
Brian?
I think that, you know, unfortunately, as long as there's no enforcement, there'll be more non-compliance. That's just the way it seems to work. There has to be one or two well-publicized cases, and then you'll have the lion's share of the rest, you know, get back into compliance. And think about it. And I think that you could also change the format of the Form C, where similar to a 10K or 10Q disclosure at the end, where you sign and certify your financials are accurate, you have a separate affirmation of compliance with Form C. In particular, filing the CAR in accordance with what's required, just to put people on a little bit more of a heightened notice, in case they're just totally unaware of the requirement, that there is a follow-up that is needed annually in order to be in compliance.
Yeah, I like the idea of adding something to the Form C to say, by the way, as you are signing this, you know, please note that there is an ongoing reporting. But that's also dependent on the issuer actually reading the thing that he or she is signing. which, as we know, there's very much, when you look at the signature pages in the Form C, and sometimes even the ones that go through the intermediaries, you're not even getting all of the people who are supposed to signing. I mean, this is something that, Peyton, you're probably very experienced with. The officers, directors, CEO, chief accounting officer, chief financial officer, they're all supposed to sign. And sometimes you see one dude and he's just like the CEO. And so, yeah, it would be great if we could have that. Sorry?
Right. If I give you 10 grand, I'm going to follow up and say, what happened to that? This isn't just money I'm tossing out the window. I do want to see what's going on with the business. I do want updates. I do want, so the investors should be policing this themselves, really.
I think that's a great point. I mean, investors should be demanding this. And whether they do it through the intermediaries, because some of the intermediaries leave the updates page open even when the raise has finished. I mean, that's one place to communicate with them. And then, investors should be calling out issuers who are not giving them the information that they promised. I wish they would do that more. I'm not seeing any more questions. Do we want to go around one final comment? Do you want to leave us with a thought? Peyton?
Well, we're here for you. At LawCloud, I mean, our purpose is to really try to offer a cost-effective solution to all of your SEC filings. So we're here to help. We're here to bring the industry standard up. And reach out with any questions. And it was great to be a part of this. And I look forward to continuing the conversation and kind of keep the momentum moving in the right direction.
Okay. Brian?
I would just encourage people to reach out to experts like Maureen and Peyton and myself. Don't worry about the money. I think we get caught up in how much hourly rates are and what the whole thing's going to cost me, and am I going to open a can of worms where it's going to be outrageous. I think that focus on what you need to get done, and most of us are in the relationship building business, and we're not looking to get rich off of certainly off of CAR filings. So it's just a a process, and you really need to find people who have experience and have good advice, especially if you're brand new to any kind of capital raising. There's a lot of landmines in the U.S. regulations, and one conversation could really change your whole outcome.
And Maureen?
I'll just, echo what Peyton and Brian said. And I would just say that, like, it's okay to also ask questions. And, if you really want to understand, what's going on, I think it's okay to ask questions, because I think some people feel like, if they ask questions, and it seems like they don't know, but the whole point of this is to ask questions, especially because, to Peyton's point, is kind of new, even though it feels like it's been forever. It's been out forever. But, and there was a learning curve for everyone, right? I remember just onboarding the platforms back in 2016, 2017. That was like, what the heck is going on? So, as things improve and as we get more information, and you learn about this process, ask questions, and we're here to answer and help.
All right. Devin, over to you.
Well, thank you all. I am just so grateful for this discussion. It's been a riveting hour, and I am thankful that you would take the time to do this, because this is so incredibly important. I want to invite everyone who's listening to join us next month for our CFPA webinar. CFPA is also co-hosting a webinar with Woody Neese next week on the Superpowers for Good, the SuperCrowd website. So visit the supercrowd.com to register for the webinar with Woody for free next week. And we will see you all next month at our monthly webinar. And again, thank you, Sara, Peyton, Brian, Maureen. You did a great job. We're grateful for you. And we'll see you all again soon.
Thanks.
Bye-bye.